Can everyone hear me well?
Yeah.
Okay. We're very happy to have Professor Kim here with us for our second Colloquium of the fall series. We're sorry to everyone for the technical difficulties, but now we're all set. And we're happy for everyone to join us. And so Pauline Kim will talk today about manipulating opportunity. She's a professor at the Washington University Law School in St. Louis, and she has been working on the role of technology intermediaries in shaping labor markets, the possibilities for artificial intelligence systems to avoid human biases in making personal decisions, and many other more problems related to the impact of technology in the workplace. Her research interests are related to issues affecting workers, privacy, discrimination, and job security. She's also a graduate of Harvard and Radcliffe Colleges and Harvard Law School. And she will be talking today about manipulating opportunity, online market and intermediaries, and risk of discrimination. So without further ado, welcome Professor Kim.
Great, thank you so much. I'm delighted to be talking to this group. I'm a lawyer by training, and so I tend to focus on legal and regulatory aspects of these questions, but I'm really interested in hearing from a much broader interdisciplinary group because as you'll see as I go through the talk, in many ways I think the law is inadequate to deal with a lot of the challenges that we are facing right now. So in some of my prior work, I've focused on employer use of automated decision systems for making hiring and other HR types of decisions. What I'm doing in this paper is shifting the focus even earlier and looking how similar technologies relying on predictive algorithms are being used by intermediaries in the labor market. And specifically, I'm concerned about platforms who operate between job seekers and firms because they play an important role in channeling information and structuring the interactions that occur between workers and firms. So there's been a lot of recent attention about online personalization and how that's affecting consumer and political markets. And in particular, concerns have been raised about manipulating consumers or voters by controlling the information or shaping the information they receive. And the primary worry in those contexts has been about undermining autonomy and rational decision-making. But what has been less noticed and talked about is how these same sorts of techniques of personalization could pose some risks to equality and values of non-discrimination. So because online platforms are increasingly controlling information about certain key opportunities like employment, access to housing, access to credit, and other financial services, it matters quite a bit how they're operating and how they're distributing information. So my focus will be on the labor market because that's my sort of area of specialty, but I just want to note here that similar kinds of concerns could also apply in these other markets. It could affect the way in which access to housing and credit could be distributed as well. My central concern here is that information about these crucial opportunities, and again, particularly in the labor market, are being channeled in ways that may reproduce and perhaps worsen existing patterns of segregation and inequality in the workplace. In other words, that these systems may work to undermine equal access to employment opportunities. So this is the plan. I was going to talk a little bit about the risks of inequality, why those might be, some of the challenges that these new developments pose for the law, and what might be some alternative responses for dealing with these challenges. So Title VII is the principal federal statute that prohibits discrimination in employment. There are a couple of other federal statutes as well, but I'll mostly talk about Title VII because it sets the pattern for the other statutes. And Title VII was part of the Civil Rights Act of 1964. It was aimed at ensuring equal opportunity regardless of race, sex, national origin, or religion. And when Title VII was passed, there were a handful of ways that were understood to be the ways in which employers could recruit and hire employees. They could advertise, they could go to job fairs, they could rely on word of mouth, rely on their employees, their existing employees to spread the word of job openings, or they could engage an employment agency or a labor union to help refer new workers to them. So Title VII was concerned with dismantling those existing patterns of occupational segregation and ensuring equal opportunity. And so the statute targeted each of the mechanisms known at that time to affect access to employment. Employers could be held liable under the statute if they engage in discriminatory practices. Discriminatory advertising was made unlawful, and then also employment agencies and labor unions could be held liable if they were making referrals in a discriminatory way. So today we have a number of new intermediaries in the labor market. Kind of roughly to categorize them, we have online advertising platforms like Facebook and Google that distribute ads that employers might place. There are job matching platforms that are dedicated specifically to try to help job seekers and employers connect with one another and to make good matches. And then there are passive recruiting systems that try to use data and analytics to locate workers who have the necessary skills that employers are looking for, but those workers might not be actively searching for jobs at that point in time. And so I think that all of these new intermediaries just deserve more attention because they are influencing the way labor markets are working. So we're all familiar with how personalization techniques affect consumer markets. They influence what ads we see when we're online, and that ecosystem is fed by data about our own past behavior and attributes about ourselves and inferences that the platform is able to make about how we will behave in the future and what our interests are. So if those same techniques of personalization are being used by these labor market intermediaries, they could potentially raise some concerns depending on how the predictive algorithms are being built and how they're deployed. So I'll just walk through some examples. I'll use Facebook as an example for the online advertising space. This is probably familiar to many people. If you're an advertiser and you want to send out an ad on Facebook, you go to a particular site, you can pick your audience. And one of the things that Facebook does is to allow you to pick audiences to include or exclude based on certain demographic characteristics. And some of these are explicitly linked to protected categories like age and gender. Others, like location, have raised concerns because of housing segregation. Location can become a proxy for race. And then in addition, there are thousands and thousands of attributes that advertisers can use to identify their audience by either including or excluding these groups from a particular audience. So I just picked a handful of attributes here that are available on Facebook that obviously correlate with age that an employer could use if they were trying to, for example, target a younger applicant pool and avoid getting applicants who are older. So these particular issues have received a lot of attention. There were lawsuits that were filed that raising the concern that Facebook was allowing advertisers to discriminate by allowing to choose their audience on these bases. And so those lawsuits earlier this year were ultimately resolved. Facebook entered into a settlement in which it agreed to remove some of the more problematic targeting options for these particular types of ads. So under the settlement, Facebook agreed that there would be a separate portal for advertising wanting to post housing, employment, or consumer ads. And in that separate portal, no demographic targeting would be allowed, no use of attributes that are, quote, direct descriptors of or semantically related to any of the protected classes. So things like the young and hip, for example, presumably would not be allowed in this special portal. And then any location-based targeting had to have a minimum 15-mile, that should say radius, not radium, 50-mile radius that would make it harder to do to use it as a proxy for race. And so the idea was by limiting the attributes that could be used, the targeted audience would then be neutral along these protected class lines. The problem is that in addition to the advertisers targeting, Facebook also uses an algorithm to further target which users will actually receive the ad within the targeted audience. So depending on how that algorithm works, the actual recipients may not be, in fact, an unbiased audience. Now, how exactly this works is a little bit opaque, of course, but we do know that Facebook is trying to predict interest, trying to predict who's going to interact with the ad in order to maximize revenue. And so that algorithm is going to be based on some combination of past behavior and attributes and inferences about how certain people will behave and respond to certain ads. So there is some evidence that employment advertising is being delivered in a biased way. There was a study by Amit Datta et al. In which they created computers that were simulated to be either male or female users, had them engage in identical search behavior that signaled that they were looking for a job. And as you can see, there was unequal delivery of ads. The one that they highlighted in particular was an executive coaching, an ad for executive coaching for high-level positions. Another study was by Lambrecht and Tucker, in which they sent out a STEM ad that was targeted on a gender neutral basis, but they found that it was shown more than 20% more often to male users than to female users. And since they selected the target audience, they knew that it was not the choice of the advertiser, it was something about the ad ecosystem that was producing this difference in the ad delivery. Most recently, there was a study by Ali et al. In which they served through Facebook a number of employment ads with sort of neutral photos and graphics, and found that the ads were distributed in a way that was neither gender nor race neutral. And if you look at the kind of the summary there, you can see that pretty much the delivery of the ads tended to follow what you might think of as sort of stereotyped assumptions about who works particular types of jobs. So these studies at least document that there's a potential for discriminatory ad delivery, even though we're not sure of the exact mechanism. But because predictions are likely inferring interest based on users who are similar, there's a real potential for this kind of discriminatory patterns in the labor market to be reproduced in the way ads and information about jobs are distributed. So there are other platforms that are more specifically focused on matching employers and potential workers. I think ZipRecruiters, you've probably seen ads, or they're one of the major players in this space. So in that kind of a system like ZipRecruiter, if an employer publishes a job posting or uploads a job posting, ZipRecruiter will scan the tens of thousands of resumes it has access to, will look for the best matches, and then nudge certain people to apply for the job. Once they apply, the employer will receive a ranked list of recommendations, and some of the applicants will be kind of marked out as, you know, potentially great matches. And then the employer has the ability to give an applicant a thumbs up. And when it does so, then the algorithm will go back and try to find other people in the pool who are similar to the people who have gotten the thumbs up from the employer. So you can see in a system like this, the algorithm is intervening at multiple stages in the matching process, trying to narrow down who is most likely to be interested, who's most likely to be a good match. Passive recruiting systems, I won't talk about a lot, but they operate similarly. The algorithm is basically reviewing information about workers and trying to predict who has the relevant skills and who's going to be likely to move, who's the employer is most likely to be interested in. So currently, we don't really have any solid empirical studies about how these job matching platforms are working or what kind of effects they are having, but there are reasons to believe that similar effects might be occurring. And that there are risks of bias prediction in all of these different labor market intermediaries. So part of the reason is many of the intermediaries in this space have limited ability to observe how somebody actually performs on the job or to measure their actual job skills and abilities. So they're often going to be basing predictions on observed market behavior rather than actual skills. They're going to be, the data they're more likely to have access to are going to be things like what kinds of employees did this employer like in the past? What kind of employees have held jobs like this or applied for jobs like this in the past? And there's a risk that that data may incorporate biased judgments on the part of employers, or to the extent that workers are underrepresented in certain workplaces, that may reflect historical patterns of bias in those workplaces. So for example, if women are rare in certain workplaces, and it's because of past bias or because they've experienced systematic sexual harassment that has driven them out of a particular type of workplace, then they're not likely to be predicted to be a good match for those jobs. And so the risk is that those past behaviors and past biases are being baked into these predictive systems if they're only looking at behavior rather than underlying skills. So this I think is a real possibility. Again, I don't think we have limited empirical evidence, but it shouldn't be surprising that these risks are there because the algorithms are looking at past patterns to make their predictions. And in employment markets, those past patterns are often incorporating past patterns of occupational segregation or bias on the job. The one anecdotal piece of information we have, or one anecdotal example, is the Amazon tool that was reported on a couple of years ago, where Amazon was trying to build an AI tool to go out and scrape information about workers to try to identify software developers that they could hire. And they trained the system by they trained the system on their existing software developers that were overwhelmingly male. And so the tool learned to go out and identify primarily males for this position, downgraded women, even though they might have had similar skills. But if there was something on their resume that suggested, for example, that they were part of a women's, a women's team, or that they went to women's colleges, the program would systematically downgrade their application, or downgrade them as a potential recruit. Okay, so because of these risks of discrimination, I think that it is important to pay attention to the operation of predictive algorithms by these intermediaries. So to be clear, I'm not arguing that these intermediaries are motivated by prejudice or that they're deliberately causing these bias patterns, but the fact is that they are responsible for their effects because they are making the choices in terms of how to build the algorithms that then direct the flow of information amongst users. They're the ones who are responsible for the choices in structuring the algorithms that are producing these effects. And this control over information will have an effect on the individual job seeker because it's going to influence their access to opportunities. And it's also going to influence both the way job seekers and employers perceive what the labor market looks like and what their options are out there. And so likely to affect their behavior as well. And the other concern is it's doing so in ways that are not transparent, so that the participants in the labor market may not understand how information is being filtered, what they're seeing or not seeing, what's being recommended to them or not, or what underlies those recommendations. So what are the implications for anti-discrimination law? I think that these new technologies pose a lot of challenges for the law. Traditionally, anti-discrimination law has focused on employer liability. And if the employer is to be held liable, it matters quite a bit who an applicant is. So for example, in order to bring a hiring case, an individual would have to show that they had actually, a failure to hire case, an individual would have to show that they actually applied for the job. The role of these intermediaries in screening people out before they even get to the application stage may make it a little, may mean that they are influencing who is actually an applicant. This also matters in class cases because plaintiffs typically rely on statistical evidence, and that often requires a comparison between an employer's workforce and the relevant labor market. Sometimes the argument is made that the comparison should be between the employer's workforce and the applicant pool. And so again, it matters very much who is considered an applicant or not. And it makes sense when you're talking about employer liability that they shouldn't be held responsible for not hiring somebody who never applied. But if we're concerned about equal access to opportunities in the operation of the labor market more generally, then if these tech intermediaries are having the effect of screening people out before they even get to the applicant stage, that is a concern, and it may mean that the law needs to sort of broaden its focus there. There are some possibilities for this kind of expanded focus in the law. Title VII does, as I said earlier, hold employment agencies responsible for discrimination, and there are arguments that in some cases, depending on how they operate, a platform might be operating as an employment agency. Under the law, an employment agency is one that regularly undertakes to procure for employees employment opportunities or to procure employees, potential employees for employers. And so to some of these platforms, that definition might apply. There's also a theory under Title VII where an intermediary could be liable if they interfere with a third-party relationship. So it's not the employer themselves, but a third party steps in and controls access to employment information, employment opportunities in a discriminatory way. So there is the possibility that this is by no means a sure thing, but there's some possibilities for interpreting Title VII in ways that might allow the law to reach these tech intermediaries. But I think there's some really practical obstacles, even if the legal obstacles could be overcome. I guess I should also mention in terms of legal obstacles, even if Title VII were held to apply, there's an argument that Section 230 of the Communications Decency Act would bar any kind of liability for the platforms. That argument turns on the language in Section 230, which says that no website shall be treated as the publisher or speaker of any information provided by another information content provider. The idea behind this defense that was created was that websites that rely on user-provided content couldn't possibly vet all of that content before it was posted. The websites would be overwhelmed if that was their job. And so this provides a defense if, for example, somebody posts something on Facebook that's defamatory, the person who's alleging they have been defamed can't sue Facebook. They could sue the individual who posted it, but the website wouldn't be treated as the publisher or speaker of that information. And so the courts have read this defense rather expansively, and platforms have relied on it in all kinds of contexts in order to avoid liability. And there's a whole sort of, complex doctrinal area that's evolved around this. But in this particular context that I'm concerned with here, I think there's an argument that this defense under Section 230 doesn't apply at all, at least to the extent that the problem is the way in which information is being distributed. Because the defense applies when you are trying to treat the website as the publisher or speaker of the information. And I would argue that and that's usually when there's some kind of a harm, that there's some kind of allegation that the content is causing harm, for example, in the case of defamation. And I would argue in the context that I'm concerned about, the concern is really not with the content of the information. The content is good. The problem is the way in which the information is being distributed. And so the activity of the platform that is being targeted is really more analogous to sort of business or commercial decisions rather than speaker or publisher functions. And so this defense arguably shouldn't apply. In some cases where the platforms are more actively involved in, for example, maybe promoting particular matches or recommending particular job seekers, there's another argument, which is the platform in that case is actually acting as a publisher, but the particular defense wouldn't apply when the website itself is acting as an information content provider, when it's actually contributing to the materially illegal content is the language that is used. But in this case, if it's their suggested matches or their recommendations that are occurring in a biased way, then arguably it would fall under this exception to the Section 230 defense. And that was one that was laid out in a case called roommates.com that was decided by the Ninth Circuit. I'm happy to talk about it later if anyone wants to get into the legal stuff more. So even if we can get past these legal hurdles, though, I do think there are a number of practical obstacles. The first is just detecting when these systemic effects are occurring. And when you have an individual who thinks they might have been harmed, or maybe they didn't get a job, didn't get access to opportunities because of these systems, it's going to be very difficult for them as an individual to detect what's going on first. And then second, even if they could somehow show that this was happening on a systemic level, being able to show individual harm could be hard. The traditional legal model is based on the idea that there was a discrete event in the past that was infected by discriminatory bias that harmed a particular individual. But really what the concern here is more about how systems may operate in ways that disadvantage certain groups. And it's going to be very hard to use that old retrospective individual liability model, I think, to reach some of the challenges here. Then in addition, we have the challenges of dealing with machine learning systems that are actively updating all of the time, figuring out what's sort of happening and how any kind of effective injunctive relief could be crafted by a court, given the way in which courts work, which is, again, retrospective in orientation and often sort of very slow in moving towards resolutions. So a number of alternative approaches have been suggested and to the liability model, and these are more prospective, forward-looking regulatory models. There's some scholars that have been arguing that FTC enforcement of unfair trade practices could be extended or expanded so that when algorithms are acting in a way that is producing unfair discriminatory outcomes, it should be considered an unfair trade practice and subject to FTC enforcement actions that would prohibit those practices. There are some people who are arguing we should look to the GDPR, the European Union's General Data Protection Regulation, as a model, and the GDPR requires firms that use automated decision systems to provide information about those systems, including meaningful explanation of the logic involved to subjects of those systems, and also to act in ways to mitigate harm. And there's a bill that was introduced in Congress, which is obviously being eclipsed by other events, but it's the Algorithmic Accountability Act, which among other things would try to create a regulatory system that would require firms that use decision systems or algorithms in high-risk decision-making, so including things that would risk causing discrimination, requires those firms to conduct impact assessments to understand and try to mitigate some of the risks. So this is very much a part of the broader conversation. People have been talking about what are the critical elements for any kind of a regulatory response. And clearly there are some certain critical elements: transparency, public awareness and input when there are these trade-offs between things like fairness and accuracy, and that these systems have to involve ongoing auditing because the systems are so dynamic. I think the difficult thing and where the challenges are is even if you have all of these things in place, if you've got a regulatory framework in place, you have these elements, you still have to figure out sort of what are the substantive standards that we're going to be applying. And that's going to differ a lot, I think, from across different domains. In the employment space, these are things that I have heard sort of being floated as possible responses. I am very interested in hearing from people in this community about sort of what are possible ways of addressing these issues from a technical perspective or figuring out from a technical perspective when or how we can, how these problems have been mitigated, or alternatively, are there workarounds that can help job seekers or companies that are really interested in diversifying and don't want to be inadvertently having their pool screened in ways that they might not actually agree with. And then I guess the last thing I want to say is I just want to make the point that regardless of how many technical solutions we come up with, we always also have to remember that all of these technologies are embedded in a particular social context, so that if, even if somehow the problem is solved in terms of equal access to information and the hiring algorithm is perfect in terms of not being discriminatory, if we're not paying attention to conditions on the workplace and how that affects people's opportunities and their ability to succeed, we're still not solving the problem. And at the same time, there's social context on the front end, who has access to these systems. Even if the systems are distributing the information in an equal way, we still need people to have access to the systems themselves, and as well as the ability to obtain the skills that are necessary to compete in these markets. So that final note is just to kind of keep that broader social context in mind, even while we try to resolve some of these technical challenges. So that's all I have, and I would just love to hear any comments or input. And I just, most of what I've been talking about is in an article, which is forthcoming next year, but is available on SSRN if anyone wants to take a look.
Oh, thank you so much, Pauline. That was really amazing. I think one thing that resonated a lot with me was also when you mentioned the idea of detecting systemic effects, and even the idea that a lot of, even if we're detecting the systemic effects, solving them becomes more difficult when they're embedded into into a social context. And one interesting part of one of the papers you mentioned by Ali et al. In Discriminating on Facebook Advertisement was this experiment they did on seeing how even if a targeter and an advertiser is completely fair in who they're targeting, the algorithm itself, it's also creating some bias from the bias that exists in a network. And it's not clear to me whether that can be solved only technically, or there's some like social or policy, social aspects or policy aspects that can be introduced there for solving this. But I'm wondering what you're thinking about the systemic effects. Is there, how can we audit these systems? Is there a legal framework that could help auditing these big platforms?
Yeah, so that's a great question, because a lot of this, is really sort of speculative because we don't have really hard data or really good studies. So right now, there is no established framework for allowing that kind of auditing. With the Ali study, they just engaged as advertisers and then kind of set up their experiments that way and could look at the outcome. With some of the job matching platforms, I think it would be difficult to do that, because it's not clear that just by signing on as a user that you could get the relevant data to actually figure out what the effects are. And so some of the regulatory frameworks that I talked about earlier that people are proposing, they're not very well flushed out, right? But I think that would be one of the things to keep in mind is if we are to create a regulatory framework, part of it might be just the first step really is trying to figure out how to allow effective auditing of the system just to understand what's actually going on, right? And so I think the one thing is there's some concern among researchers that if they do too much experimentation where they are sort of running experiments that are not actually, say, looking to hire somebody, but they're creating false accounts in order to figure out the effects of these things, they're worried about potential liability under the Computer Fraud and Abuse Act. And so that's an area where I think a little more attention in the law to the importance of doing these kinds of studies could relieve some of the fear of liability on the one hand, and then on the other hand, these regulatory structures could be designed in a way that allowed for a little bit more experimentation and auditing by outside groups without necessarily threatening the operation of the platform or threatening to reveal any trade secrets or anything like that. It would still give us more information about the risks of the systems.
Thank you. Definitely, that makes a lot of sense. I think in a lot of the studies, well, the few of them, for example, the LA one, a lot of efforts were concentrated on reverse engineering a lot of what's going on. And I think it would be great to relieve some pressure from doing all this reverse engineering and providing better ways to, as you said, to experiment with this kind of data.
Mm-hmm.
All right, I want to open up the floor for everyone else who has questions or comments.
Can you hear me? I had a question.
Yeah.
Nice. Okay. Really great talk. Thanks so much for doing this. And I think there's going to be some overlap with the last question. I found it really interesting, the idea that like employers can't discriminate if you don't apply, right? And that really makes like the whole ZipRecruiter aspect interesting. Say ZipRecruiter did try to extend, put in some effort to show employers diverse candidates, right? But they showed every different employer the same diverse candidates, right? You can't accept more than one job offer. You can think about maybe like this would be sort of like a form of gerrymandering. Maybe that's not the right word, but you could sort of gerrymander these job offers, and obviously, you can only take a certain subset. Is there any way to like? It's hard to say that any individual has been discriminated against there. So it sounds like the law would not allow you to have any recourse. So is there any way to actually incentivize ZipRecruiter to sort of not engage in this behavior?
Yeah, so two things that's interesting. The whole reason why the traditional Title VII model doesn't work so well is because it's looking for an individual victim, right? An individual victim of discrimination who can point to the discrete event or the particular person who had a discriminatory motive. And this is sort of a different problem, right? Because, and again, I want to be careful that I'm not saying ZipRecruiter is doing anything wrong, and I certainly don't want to say that they're intentionally doing anything wrong, right? But these effects occur on a systemic level, and so that requires looking at the systemic effects. What are the overall patterns here? Are they having the effect of disadvantaging certain groups? Which I think is if they are having that effect and the groups that are being disadvantaged are historically disadvantaged and marginalized groups, that's a matter of social concern, right? And we ought to find a way to address that. But the way to address that is not necessarily going to be that one person can step up and say, oh, I was the person who was discriminated against, right? And I think that that's kind of your point there. So then, and a lot of the old legal model has been premised on the idea that, well, if employers are going to be held liable for discrimination, then they'll have an incentive not to discriminate, right? They're not going to discriminate because they'll get found out, they'll get sued, they'll have to pay damages. But if that model breaks down, then we have to find a different way of creating the incentives, right? And I think that's why people are starting to talk more about these regulatory models, which would be, well, it's not that you're going to be sued by a particular individual, but in order for you to use these kinds of systems, there needs to be some kind of scrutiny of them, right? And it's not enough for the provider of the service to say, okay, we're providing a platform, it's neutral, we've checked, we don't use race as a criteria or gender as a criteria, so we're done, right? That because of the risk that even if they're not deliberately biased, the risk that prior biases and patterns will be encoded in what they're doing means that there needs to be some kind of a check or scrutiny of the system. So I'm not sure I'm providing a very good answer other than I think you've identified the challenges, and that's part of the reason why there is increasingly a talk about shifting away from a retrospective liability model to more of a prospective regulatory model. What that looks like, there's still a lot of work that needs to be done to figure that out.
Okay, thank you.
Anybody else? Any other questions or comments?
I had a question about actually two questions. One was about, you mentioned Section 230, how it had previously interpreted, and your view on how it should be interpreted given sort of the current role of platforms as intermediaries and how the distribution of information is actually possibly causing discriminatory outcomes. And I was wondering, like, forgive my ignorance, but what sort of legal process would need to happen in order for that reinterpretation to occur? Is that even possible? And then also the Algorithmic Accountability Act. I was wondering if you could give some sort of overview on, for example, do they employ any of the possible technical solutions or encode those into their language that you suggested, for example, constraints of distributive outcomes? Because I think especially constraints of distributive outcomes is something where this community, there are a lot of people thinking about what are appropriate definitions of fairness. There are results on impossibilities that you can't simultaneously have a lot of them together. And so from my limited knowledge, what I see is that if one of them has been encoded, then sort of people will, or platforms will adjust their algorithms to stick very closely to one measure of fairness, but they may not be able to meet the other ones. So yeah, a few questions there.
Yeah, okay. So on the Section 230, the way in which the 230 issue comes up is as a defense. So the first step would be sort of overcoming all the problems we just talked about in response to the last question, right? That you actually have somebody who can say, I was discriminated against, they figure out what's going on and they bring the lawsuit and they are able to make a case under, say, for example, Title VII, that let's say they make an argument that this platform is an employment agency and they have been referring people in a discriminatory manner. Then the next move would be the platform would say, okay, well, even if you're right about all that, of course, they wouldn't agree with it, but even if you're right about all that, we have a defense under 230. You cannot hold us liable because of this defense. And I don't know how familiar people are with that, the 230, but the Communications Decency Act was passed in the 1990s, and the intent behind the act was the primary motivation was to prevent young people from getting access to pornography. And so there were all kinds of restrictions that were put in place, and the defense in 230 was kind of like just a kind of almost like an afterthought, right? And the main part of the act got struck down on First Amendment grounds, but Section 230 has just sort of grown in importance. So as platforms have grown in the ways in which they have their, sort of their role and their provision of information has grown, they have gotten sued more and more often because of harms that people allege were caused by the information that they are distributing. And they have consistently relied on Section 230 as a defense and said, we're just not liable for anything that comes up on, that somebody else has provided, we're not liable. And courts have applied that far beyond the initial example of defamation to all kinds of claims, including some discrimination claims. And so but in almost all of the past cases, the plaintiff was bringing a claim that was alleging that there was something about the content that was harmful to them, that it promoted terrorism, that it was revenge porn, that it was inflicting emotional distress, it was defamatory. And in those cases, the court have said, yes, the platform has this 230 defense because they can't possibly go out and vet everything before somebody posts it. And I want to say that this particular situation is different because it's not about the content. There's nothing harmful about the content. In fact, the whole point is this is good content. I want to know about jobs. I want to know about housing opportunities. I don't want to be excluded from those because of some assumption that's made about me based on my demographics, right? So my argument would be that the 230 defense shouldn't work in this context because what's really being challenged is the way in which the platform is distributing the information. Now, the way in which it would come up is you'd first have to get through those other hurdles. You'd have to get somebody who could sue and get through the hurdle of showing that they actually had a claim that applied in this new context. And then we would confront the 230 defense. So again, the part of the point is, yes, there are some legal avenues for making the arguments, but there are an awful lot of hurdles to get over on the way there. So your second question was about the Algorithmic Accountability Act. And that act is really quite bare bones. All it really says is that it empowers the Federal Trade Commission to create regulations to require firms to assess the impact of algorithms and to think about the risks and think about ways of mitigating them. So it's really the only thing, if it were to go forward, the only thing it would really do would be to create a structure that would authorize the FTC to start looking at these questions, but it doesn't try to impose substantive standards, and it's not even clear that it's calling for the imposition of substantive standards. It's just saying that there ought to be scrutiny, there ought to be some kind of impact assessment going on. But of course, the hard thing is, even once and I think setting up a system like that would be an important first step because it would then start to create more transparency. It would allow for more systematic study of the effects of sort of how these platforms operate. But even having done that, there still remains this question that people are struggling with on the technical side, which is, well, then what's the fix, right? How do we, even if we know we're having these systemic effects that are troubling, what's the response, right? What's the appropriate response? What is it that we kind of set as a standard for firms to meet to say, okay, if you've done this, you're okay. And that's the hard part, right?
Great. Are there other questions or comments?
I have another question if nobody else does. So going back to one of the early points or examples you made up, you brought up, which was, oh, I'm already forgetting what the exact point you made was, but I remember you talked about the Amazon employment scraping tool and how it was vastly sort of prioritizing men over women. And I was curious, you had some more general point here about, yeah, I'm forgetting the general point, but my question was, in these kinds of algorithms, techniques that you were describing and possibly critiquing, I was curious, first a clarification question, were any of these algorithms actually using protected characteristics or correlates to suggest the job? And also a related question is, in my mind, there's kind of two ways that bias may enter. Well, many ways, but two of the ways that bias could enter are you're using historical data that you haven't really verified is not biased in order to train some algorithm, or you're actually, but that data is not directly, you would have to do some work to determine that it's correlated with things like gender or race or things that are protected characteristics. And then, so one example would be, say, just looking at historical employment. Looking like when you look at people who are like this person, you could look at people who are like this person on various features, or you could look at people who are like this person in terms of their previous jobs and try to do some kind of matching on those dimensions. Do you think there's sort of a distinction between these kinds of features, processes? Do you think there's value to kind of rolling out regulation or these kind of constraints on processes, outcomes in like a staggered way? Or yeah, because I think if we wanted to eliminate bias altogether, there's almost like no information left out there that could be used, right?
Right. Yeah, so in terms of your first question is about what exactly they're using, and I have no idea. I mean, I assume they're not using protected characteristics.
Mm-hmm.
But they don't, of course, they don't need to, right? So they're the reason the reason that I am concerned, and I think it wouldn't be surprising if these systems produced biased patterns in terms of the distribution of information, is because if you look at past behaviors, our job market is characterized by segregation on race and gender lines, right? There was some improvement after the Civil Rights Act was passed. Progress kind of stalled. There's some evidence that racial segregation might have actually worsened in the last decade or two. So if you have kind of an agnostic program that is just looking at what kinds of people have had this job in the past, they are going to see patterns of occupational segregation on race and gender lines. And then, so it would be natural to sort of reproduce those, right? Now, the hard challenge is that some of that occupational segregation could be a result of bias, either biased judgments or sort of channeling, but some of it may reflect real differences, for example, in educational background, right? So if you're advertising a job that requires a law degree, right, you will probably get a different distribution of potentially qualified applicants than if you're advertising a job for call center worker, right? And so just the fact that there's a discriminatory or bias pattern in the information delivery doesn't necessarily mean that it's illegitimate, but the problem is that if the platforms are not relying on job relevant categories of information, it's more likely that they're just reproducing patterns without examining how those patterns came into being, as opposed to really focusing in on these are relevant characteristics or abilities or skills for this particular job. And these are people who have those skills and abilities. I'm not sure the platforms have that information, right? The job matching platforms, which is why my guess is that they're probably tending to look more at sort of more superficial attributes and historical patterns. And then the job matching platforms, a lot of what they're doing, I think, is observing people's behavior on the platform itself. And that's where we can't be sure that discriminatory preferences or implicit biases aren't being encoded, right? So if this employer is giving a great match to these 3 employees and we go look for other employees that look like them, if the employer's choice of who those 3 that they gave the thumbs up to is affected by some kind of implicit bias, it's just going to be reproducing that bias if that's the pattern that it's basing its predictions on. I don't know if that is helpful or responsive to your question, other than to say, yeah, I know it's hard, but I think it's important to really try to get at what are the relevant bases for prediction as much as we can, as opposed to just sort of whatever's out there that can predict the patterns that we see.
Maybe I'll jump in with one last question if nobody has one.
Mm-hmm.
Maybe a few minutes. So I was wondering if you had any perspectives on if we were to come up with constraints on distributional outcomes, for example, imposing that job ads there has to be equal or equitable access to job postings or ads. What could be appropriate notions of equality or equity in this situation? So I've seen there's a recent paper on sort of preference-aware equity, which is sort of saying that, okay, it may not be going out to exactly 50% men, 50% women, but this could be because of the agents themselves have expressed past preferences that are being used. And this is different to say, for example, predicting their preference based on the people like them, right? So have you thought about what are notions that are sort of like one way we could impose things is just, okay, like for these protected kinds of information, it has to be 50% men, 50% women. It has to be 50, like or following like the population distribution of age. But are there sort of more flexible things that, from maybe like a legal perspective, are there precedents for how to think about this? Yeah.
So the one thing I think that is not directly relevant, but is sort of useful in thinking about this from past legal cases is when I was talking before about, in order to bring a class case, you have to show that the plaintiffs would rely on statistics, and they would say, look, this employer's workforce really is really skewed, right? Really skewed in why it's overwhelmingly white or overwhelmingly male, given the relevant population. And one of the defenses that employers would often use in that context would be to say, well, we should really look not at general labor market statistics, but we should look at our applicant pool. And if you look at our applicant pool, it's overwhelmingly white and overwhelmingly male. And so, it's not that we're engaged in any discrimination. It's just that maybe people of color, women just don't like these jobs. They would prefer not to have these jobs, right? And the courts have done 2 different things in that context in the past. And it tends to break down on whether they were cases based on race or sex. In a lot of the race cases, the court said, no, you can't rely on job applicant pool statistics because you have been discriminating in a way that, if you're a Black worker, you're just not going to apply, right? If you've sent out a message that you only hire certain kinds of people, people who know that they're not likely to get the job just aren't going to apply, right? And so that would not be a defense in and of itself if there was some kind of barrier that the employer had put in place to prevent people from applying. And so it, introduced this idea that people's preferences are shaped to some extent by their experiences on the labor market. And that wouldn't necessarily be a defense. Now, interestingly, in some of the sex discrimination cases, courts were more willing to say, well, yeah, for this particular, sort of job that involves manual labor, yeah, I don't think women would be interested in this, right? Or there was one where it was something that involved commissions, and the court just sort of assumed, well, yeah, women don't like a more competitive environment, so they probably weren't interested in these kinds of jobs, right? That's highly problematic, I think, because if there's an assumption being made that these preferences are sort of pre-existing, then they're just going to be there. There's the risk that they're reinforcing existing stereotypes about who can do what and who's interested in what. So on the one hand, I think the lesson from these old legal cases is there's a reason to be a little bit careful about assuming that express preference is the same thing as ability and potential preferences, because people's preferences can change over time, and they can change in response to the circumstances that they encounter on the job. On the other hand, the fact that somebody is actively currently expressing a preference is probably a more legitimate way than, well, I think it is a more legitimate way, or less concerning way of distributing the information than inferred preferences, right? So if somebody clearly, you put in my feed a whole bunch of jobs, and there's a certain category of job that every time I see it, I'm just like, no, I'm not interested, right? Then at least I have had some agency in determining what those preferences are, as opposed to their being imputed to me based on what somebody else whose profile looks somewhat like mine, might have done in the past.
Great, thank you.
Mm-hmm.
Great, thank you so much. If nobody has any other questions, perhaps we can wrap up here. All right, thank you so much, Professor Kim, again for a wonderful presentation. We hope to continue talking to you about these problems. And thank you everyone who participated. We're sorry again for all the technical difficulties, but we're happy everyone was able to be here with us.
Great, thank you.
Thank you so much.
Thank you so much.
Thank you.